Yes, Mr. Willis.
My Lords, we were working through the judgment of Lord Justice Coulson before lunch in the Bromley case, which was tab 16 of the Key Authorities bundle. And I'd just like to finally ask your Lordships and my lady to turn up page 1074, internal pagination, paragraphs 104 to 109. Although I don't want to take you through all those paragraphs now, you can see in paragraph 109 at the end of the judgment, Lord Justice Coulson says this, and it's really to tie up the point about the rights engaged under Article 8. He says, finally, it must be recognised that the cases referred to above make plain that the Gypsy and Traveller community have an enshrined freedom not to stay in one place, but to move from one place to another. An injunction which prevents them from stopping at all in a defined part of the UK.
Sorry, what, you were 104, did you say?
109, my lord.
109.
Sorry, forgive me. Last page, last paragraph.
Yes.
He says, third line down, an injunction which prevents them from stopping at all in a defined part of the UK comprises a potential breach of both the Convention and the Equality Act 2010, and in future should only be sought when, having taken all the steps noted above, a local authority reaches the considered view that there is no other solution to the particular problems that have arisen or are imminently likely to arise.
What does Lord Justice Coulson mean by an enshrined freedom?
Enshrined freedom, where he's referring back to the Convention rights under Article 8 to respect for one's traditional way of life, as opposed to one's home. And in the Chapman case, the European Court of Human Rights concluded that the traditional way of life was worthy of respect.
As something to go into the balance.
Exactly.
It's an aspect
So
of Article 8.
by enshrined freedom, he can't mean a trump card.
No, absolutely. Not suggesting otherwise, but there is a positive obligation on the state and indeed the courts to facilitate that way of life. But again, everything has limits.
But it's a positive obligation with no definite content, because the court in Chapman were careful to say that there was no, at that stage, there was no common, no consensus among contracting states about what to do.
There was no consensus on the, I think, concrete consensus on the framework for the protection of national minorities back in 2001. Debatable as to whether or not, with the same facts, if the case were before the European Court at this point in time, 20 years later, they would come to any other decision. But we just don't know.
We don't know. So Chapman is Chapman the last word from the Strasbourg Court?
No. There have been subsequent cases which I referred your ladyship to before lunch. The Jordanova case, the Buckland case, which is a case relating to a site and a Romany gypsy living in Wales. These are all cases that have followed on from Chapman.
But are they cases in which the court has held that the public authority has breached a gypsy or a traveller's Article 8 rights?
Yes, my lady.
In what respect?
The Buckland case related to...
These are the cases referred to in Bromley, are they?
They're referred to in Bromley. I took your lordships and my lady to them before lunch, page 1063.
You showed us the reference in the...
Yes, I don't... the reality is I've only got another...
all right, so should we just go away and read
those?
Is that the answer? We should just go and read
If you don't mind, my lady,
right.
I appreciate that I'm not answering your question as perhaps as fully as I could, but I want to move on if I may.
Well, can you answer mine?
Yes, certainly.
Reading paragraph 109,
yes,
it doesn't seem to me that Lord Justice Coulson is saying that persons unknown injunctions cannot be granted as a matter of jurisdiction.
No,
He
doesn't. The point was not raised or debated before.
So this case is wrong in law.
Well,
according to you.
Yeah, I might take some responsibility for that, in as much as I didn't raise the point.
Whether it's your responsibility or not is not my concern. This decision is completely wrong in law.
Post Canada.
The answer to this case is that there is no jurisdiction. The court should not grant persons unknown injunction again in traveller cases. So all the guidance is a complete if I may say so, waste of time and space, because the court should not grant it.
My
And
lord,
you accord with the advocate
Yeah,
to the court's
that-
submission that that
exactly.
is the legal position.
that is the legal position.
Right.
Unfortunate as it is, that is the legal position post Canada Goose.
Thank you.
And what is said about final injunctions binding newcomers by Lord Justice Coulson and the Court of Appeal in that case is overture, because it wasn't a matter that was discussed and debated before the Court of Appeal. So can I then perhaps turn back in time to the Gamble case? And
To which case?
Gamble, my lord.
Gammon.
And indeed, the case that came before it, perhaps first, tab 6, the South Cambridgeshire District Council against Persons Unknown case, which I'm going to be told is at page 146 of the authority's main bundle.
South Cambridgeshire.
My lord, yes. And the original case against Persons Unknown, where the Court of Appeal granted that injunction, included reference to the then rules, the County Court Rules Order 49, and Lord Justice Brooke, paragraph 7, identifies those rules, and they are in much the same, if not exactly the same form as the practice direction that is before us in paragraph 20 of that practice direction. You'll see under the heading, or under the reference to the County Court Rules Order 49, 7.1, an injunction under section 187B may be granted against a person whose identity is unknown to the applicant. And then 2, an applicant for an injunction under paragraph 1 shall describe the respondent by reference to A, a photograph, B, a thing belonging to or in the possession of the respondent, or C, any other evidence, with sufficient particularity to enable service to be effected, and the form of the claim form used shall be modified accordingly. And then there's a reference to subparagraph 3, which doesn't get quoted, but that relates to the filing of evidence. Now that is followed by a paragraph which reads as follows: I am wholly satisfied that the statute gives the court the power to make an order of the type sought by the claimant. There is some difficulty in times gone by against obtaining relief against persons unknown, but over the years that problem has been remedied either by statute or by rule. And then there's a reference to the Bloomsbury case and others. And then, if I could ask my lords and my lady to turn up the South Cambridgeshire Gamble case, which is at tab 8. 165. I'm very grateful. Everybody's been very helpful. And we've been to this decision already, and we know that as far as the Gamble case is concerned, the injunction was of an interim nature.
But it's never mentioned that that's, I mean, it's never suggested that's anything to do with the decision, is it?
No.
No.
This is a case where Mrs. Gamble has been, in effect, made a defendant having moved on to an unauthorised development as opposed to an unauthorised encampment. She's now before the court having breached the order which she has been made aware of, and the same for Mrs. Winnie Moore in the Bromley case. But the short point, but I would respectfully suggest, crucial point about section 187B injunctions is that they can be granted on a final basis. That's clear from the wording of the statute, but only in relation to defendants who are either named or identified in accordance with the practice direction. been taken, Lords and my lady, to the practice direction by a number of my learned friends. It's perhaps easily found in the judgment of Mr. Justice Nicklin in the court below. Paragraph 50 of his judgment, page 39. Where he says, CPR Part 82A, brackets 1, and Practice Direction 8A impose further specific requirements in respect of certain categories of claim brought against persons unknown. Paragraph 20 applies to claims and applications under Section 187B Town and Country Planning Act 1990. And he then refers to the relevant paragraphs, and you'll see those paragraphs reflect the paragraphs in Order 49, which was the then relevant rule identified in the South Cambs against persons unknown case. And paragraph 20.4 makes it clear that there is a requirement that the applicant must describe the defendant with reference to a photograph, a thing. It might be a caravan, it might be a car, it might be the land that they own, a possession of the defendant, or any other evidence. And the description, 20.5, of the defendant under paragraph 20.4 must be sufficiently clear to enable the defendant to be served with the proceedings. And then 20.6, the application must be accompanied by a witness statement. The witness statement must state that the applicant was unable to ascertain the defendant's identity within the time reasonably available to him, steps taken by him to ascertain the defendant's identity, the means by which the defendant's been described in the claim form, and that the description is the best the applicant is able to provide. Providing there's compliance with those elements of the practice direction, then there is no bar to a local authority seeking and obtaining an injunction on an interim or indeed a final basis under Section 187B of the Town and Country Planning Act. But that is a requirement that has to be complied with.
So no newcomers?
So no newcomers. And what that leads me to suggest to your lordships...
Why can't you just dispense with service?
Well, you can dispense with service, as Mr. Bose said. Indeed, there's a reference to doing so under 20.5. But that doesn't detract from the requirement to identify the applicant, which, in my respectful submission, is an absolute requirement.
You say that you cannot comply with paragraph 20.4 in relation to newcomers because you can't photograph them, you haven't got anything that belongs to them, and the other evidence, well, there is no other evidence except an apprehension that somebody might in the future come onto your land. Exactly,
which is pure speculation, which may be based on an assumption about individuals or their characteristics. It may be impermissible if it goes beyond that, but it's pure speculation. And what I respectfully submit is that, in fact, if we look at coherence, and that's what we're looking for here, and I understand the reasons that my Lord Master of the Rolls expressed concern about the way these cases have gone, is that to be coherent is obviously crucial in this sphere. But in fact, Canada Goose is coherent with the statutory scheme under the Town and Country Planning Act.
Was it cited?
Sorry?
Was it cited in Canada Goose?
Well, Canada Goose obviously cited Cameron, and Lord Sumption looked at Section 187B of the Town and Country Planning Act and its rules. And so, in fact, when one looks at it from the point, the end of the telescope that I'm looking through, one can see that all these decisions are actually coherent with the Town and Country Planning Act provisions, and that there is no heresy here being suggested by the interveners, or indeed by the advocate for the court. In fact, the coherent approach is to accord with the Town and Country Planning regime, the statutory regime, which is consistent with the fundamental principle identified by Lord Sumption in Cameron. Now, looking at Gamel, we don't see any discussion of the rules or indeed their applicability or their compliance. The court was obviously concentrating at that stage on whether or not to send Mrs. Gamel or Mrs. Morm to prison for breach, and nobody raised a question, a mark, as to whether or not there was any non-compliance with the rule, and perhaps there was none. What we can see in the Gamel case, if I ask your lords, my lords and your ladyship, to turn up insofar as it's necessary to do so, perhaps under the heading the Gamel case, paragraph 20, we see the history set out there.
Right, what are we looking at?
Paragraph 20 of the Gamel case.
Gamel?
Gamel, yes. So we're still in tab 8. I mean, all I wanted to do was identify the fact, and I think it's agreed, I think Mr. Jones identified this for us, that it's clear that the Gamel injunction was of an interim nature. It's not so clear about the Morm injunction. I think that's as far as we've been able to get. I wasn't involved in the case and at that point in time, so we can't necessarily assist you with that. And perhaps rather than take much more time over the Gamel judgment, what I will say is this, that my learned friend Mr. Jones suggested in his note on precedent, on binding precedent, and as a consequence of discussion in this court, that there's an issue as to whether or not Canada Goose is inconsistent with Gamel. And that's an issue that your lordships and my lady will have to resolve.
Well, you say it's not.
I say it's not, my lord.
Because?
Well, for the simple reason that in Gamel there was no discussion of the first point is that it's a Town and Country Planning Act injunction case, where the rules to be applied to the grant of an injunction against newcomers require description of the offence. Against anyone who is bound by the injunction, require identification. Therefore, it rules out newcomers as.
But she was a newcomer.
And that's the second point. They weren't dealing with. They were dealing with somebody who had moved onto the site in the time when an interim injunction was in force, as opposed to a final injunction.
No, but I mean that's not a distinction that the case makes.
No, it's not, and there was no discussion about those issues, or indeed the application of the rules.
Mrs. Morm was in the same position too. The injunction in the Morm case was granted on the 8th of July 2004. She became the owner of the plot in September 2004.
Yes.
Moved in on the 26th of September 2004. So
yes.
That was all after the order had been made.
Yes, yes. Again, it brings me back to the point I made earlier on, that Section 187B injunctions are designed to apply in cases involving unauthorised development. And one doesn't expect, one might think, or one wouldn't infer that a rolling cast of individuals would effectively move on to somebody else's piece of land and push those people off. If land was sold by one person and another moved on, well then an application can be made to join that person, or alternatively that person, by the very nature of the injunction and residing on the land, becomes a defendant who can then be subject to committal proceedings. It's a completely different scenario from the sort of situation that is covered by the injunctions granted.
But doesn't that put a bit of a hole in your argument on the practice direction? Practice direction says in unqualified terms that you can grant an injunction against persons unknown.
Yes.
As indeed does the statute.
Yes.
The practice direction then goes on to say, to deal with what you should put in your claim form, which is necessarily the document by which you start the proceedings. If, as I think you accept, a newcomer can become a party to the proceedings after the proceedings have been launched and the interim injunction granted, necessarily you won't have complied with the practice direction as regards that newcomer.
Yes.
So if you accept, as I think you do, that Gamel is right, then that puts rather a hole in the practice direction.
Well, what one needs to do in that situation as a local authority trying to enforce planning control is to ensure that the individuals who are breaching that control are subject to potentially committal for contempt of court. And in order to bring them into that, put them in breach, or indeed put them at risk of committal, it's my respectful submission that one needs to go back to court one way or another to amend the claim.
Well, maybe, but what's the problem with amending the claim?
Well, nothing, but again,
once you've identified the newcomer.
The claim needs to have involve identification of the newcomer, either by reference to their name, or alternatively, if there's no way of knowing their name, by reference to a thing that they own, or a photograph, or some other matter. And that would be very easy, because one sees in the Morm case that Winnie Morm clearly moved on to one of the plots on 804 Throckmorton Farm. As a new owner, she was caught by the injunction.
So, following that one through, it sounds as though you wouldn't have an objection to an order, a final order, which said that, which gave a general permission to amend the claim form by identifying anybody who subsequently did what the injunction forbade.
Yes. I cannot see the objection.
Well,
Which again rather puts a hole in the argument that you can't make a final order. You can, depending on what it says.
If a final order is made, in fact, I think there's an example of an application made by one of the claimants in this case for a variation or an additional defendant to be added to one of their claims, a named defendant. Then, I suppose the question is the final order final, or has it been closed? We're back to issue number one. And I think that's not a matter that I necessarily want to address, given the short period of time that I have to address other matters. But what I say is that the statutory scheme, coupled with the rules of court and now the practice direction, identify the appropriate approach to take to ensure fairness and to ensure that there is compliance with the fundamental principle identified by Lord Sumption, which we've been to, and I don't necessarily want to take you back to in his judgment. And so there is no heresy in the judgment of the Court of Appeal in the Canada Goose case. And indeed, in Canada Goose, and perhaps we can turn that up, my lord, I'm going to hope that somebody tells me the page number, but it's tab 18 of the Authority Fund. I'm just being handed a note which tells me that I should tell you that you cannot add defendants after the final order. In other words, and I think the application was made by one of the claimants to do so, and it was rejected. 390. Page 390, my lady.
I don't think I understand that. You mean in these cases an application was made?
I understand that one of the claimants made an application to add defendants after an order had been made. Yes, the final.
And who rejected it?
The judge at first instance, as I understand it.
Mr. Justice Nicklin.
No, I don't think it was Mr. Justice Nicklin, but I will find out for your lordship.
Okay.
We'll definitely find that out. And the other point that I would...
So you can't do what my lord...
Yeah.
Your submission is you can't do what my lord...
Exactly, my lord.
I see.
So I think in those circumstances one would have to seek a fresh injunction in relation to the new resident of Victoria View or wherever it may be.
Well, that then does drive a coach and horses through the word of the statute. That you can bring a claim against, you can make an injunction against persons unknown.
Well, no, my lord, with respect, because the statute is qualified by...
Going past, bound by the
Okay.
people. Okay. All right.
But you see my point, my lord. But
Yeah.
Canada Goose, please, 390 over the tab 18. Where does that approach leave a local authority? If one looks at paragraph 91 of the unanimous judgments of the court, and perhaps before we do that, just bear in mind, my lords and my lady, that Lord Justice David Richards, who sat on the panel in the Canada Goose case, had also, to my recollection, sat on the Ineos case.
Quadrilla.
Sorry.
Quadrilla.
And Quadrilla.
Yeah.
All three.
All three, yes.
All three. I think that's it may be a jury point, but it's not as if we're dealing with a panel who had no knowledge of the other cases. Indeed, as my lord, the Master of Rolls said, there are.
Well, and Lord Justice Coulson sat on Bromley.
Well, I know.
2 months before.
And there's no mention of the Bromley case in here. I know.
No, but presumably he hadn't forgotten.
He had it in mind, in his own mind. If we look at internal pagination 2825, paragraph 89, under the heading Final Orders Against Persons Unknown, we've been through the paragraph itself on a number of occasions. And my short point on the first sentence is that what is said about protester case cannot simply be applied to protester cases. And
Why
also,
did they say it then?
well, perhaps because they were dealing with a protester case. I know not, my lord. Perhaps they wanted to leave it in that form because of that very fact. But it would be wrong in my respectful submission, and traveller injunctions come in all forms, as your lordship indicated yesterday, but be wrong in my respectful submission to differentiate between the sort of injunctions that the Court of Appeal had in mind in Canada Goose and injunctions which are sought in this case against travellers. I mean, one shouldn't clearly differentiate on the basis of the identity of the individuals, and many of the sorts of causes of action brought in protester cases are similarly to be brought in traveller cases. And we see that in the cases before us now, with nuisance and trespass and the like being causes of action relied upon in some of the cases before your lordships. And the usual principle and the fundamental principle applies equally in traveller cases as it does in protester cases. But where does Canada Goose leave a claimant? Paragraph 91 over the page, my lord, at 2826, internal pagination. The lordships say this: that does not mean to say that there is no scope for making persons unknown subject to a final injunction. That is perfectly legitimate, provided the persons unknown are confined to those within Lord Sumption's Category 1 in Cameron, namely those anonymous defendants who are identifiable, for example, from CCTV or body cameras or otherwise, as having committed the relevant unlawful acts prior to the date of the final order and have been served properly pursuant to an order for alternative service prior to the date. And what the Court of Appeal is saying there chimes with the practice direction in the Town and Country Planning. And nothing heretical about that at all. Practice direction which requires identification of anonymous defendants by other means. And then you'll see in paragraph 92, and I know the distinction between interim and final injunctions is an issue that troubles this court, but we see, and I just want to identify the paragraph, the Court of Appeal addressing the question of the difference between interim and final relief. 4 lines down, in answer to an argument put by my learned friend, Mr. Bowes, QC, an interim injunction is temporary relief intended to hold the position until trial. In a case like the present, the time between the interim relief and trial will enable the claimant to identify wrongdoers either by name or as anonymous persons within Lord Sumption's Category 1. Subject to any appeal, the trial determines the outcome of the litigation between the parties. Those parties include not only persons who've been joined as named parties, but also persons unknown who have breached the interim injunction and are identifiable, albeit anonymous. Trial is between the parties to the proceedings. Once the trial has taken place and the rights of the parties have been determined, the litigation is at an end. There is nothing anomalous about that. And that rather chimes with the point that my learned juniors asked me to make in answer to a question put by my Lord Justice Lewison. So, where do those submissions leave this court? And might be asked why these points were elucidated before, haven't been raised before. And the short answer is that, save for the 2 occasions I appeared with my learned friends in the Bromley case, and this instance, I've never appeared in a case on behalf of persons unknown. It just doesn't happen. It's by definition. It's a hallmark, I think, is the word used by Lord Justice Coulson in the Bromley case, of persons unknown litigation, that they are not represented. There was an example where their interests were advanced in the cases we have in our bundle of authorities, and that was in the Ineos case. And perhaps if I can ask you, my lady, to turn that up, tab 15. 324, my lords and my lady. And because if Gamel isn't inconsistent with the Canada Goose case, the question posed by my learned friend Mr. Jones in the court is whether or not Ineos might be. And can I begin by asking my lords and my lady to look at paragraph 16. First, at the internal pagination, page 4. And there, Lord Justice Longmore said it's a curiosity of the case that the judge made no order against either Mr. Boyd or Mr. Corrie, but they have each sought and obtained permission to appeal against the orders made in respect of the persons unknown. And they've each instructed separate solicitors, junior counsel and leading counsel, to challenge the orders. They profess to be concerned with the width of the orders and seek to be heard on behalf of the unknown persons through the subject matters of the judge's order. Friends of the Earth are similarly concerned and have been permitted to intervene by way of written submissions. And then there's a reference to any concerns about locus standi having been dissipated by the assistance that the advocates provided to the court. And then we know that paragraph 26, bottom of the page, internal pagination 6, is where Lord Justice Longmore identifies an argument raised by Miss Harrison for one of those defendants, Harrison QC. Ms. Harrison further relied on the recent case of Cameron, and it is a Supreme Court decision, in which the Supreme Court held that, and then we know what was held. And then over the page, paragraph 29, addressing the argument in paragraph 28, perhaps we should just rest on that for a moment. Paragraph 28, Ms. Harrison submitted that these categories, in other words, the 2 categories identified by Lord Sumption in Cameron, of unnamed or unknown defendants, were exclusive categories of unnamed or unknown defendants, and that the defendants as described in the present case did not fall within the first category, since they are not described in a way that makes it possible to locate or communicate with them, let alone to know whether they are the same as the persons described in the claim form, because until they committed the torts enjoined, they did not even exist. to the extent that they fell within the second category, they cannot be sued as unknown or unnamed persons. And then Lord Justice Longmore says, despite the persuasive manner in which these arguments have been advanced, I cannot accept them. In my judgment, it is too absolutist to say that a claimant can never sue persons unknown unless they are identifiable at the time the claim form is issued. And then he goes on to address the Bloomsbury and Hampshire waste cases. And about 9 lines down, at the end of the line, Lord Sumption's 2 categories, if you follow me, apply to persons who do exist, some of whom are identifiable and some who are not. But he was not considering persons who do not exist at all and will only come into existence in the future. I do not consider he was intending to say anything adverse about suing such persons. On the contrary, he referred, para 11, to one context of the invocation of the jurisdiction to sue unknown persons as being trespassers and other torts committed by protesters and demonstrators, and observed that in some of those cases proceedings were allowed in support of an application for a quia timid injunction, a precautionary injunction, that should read, where the defendant could be identified only as those persons who might in future commit the relevant acts. He goes on to quote from paragraph 15 of Lord Sumption's judgment over the page. References there you'll see to interim relief. And in paragraph 30 he said, this amounts at least to an express approval of Bloomsbury and no express disapproval of Hampshire waste. I would therefore hold that there is no conceptual or legal prohibition on suing persons unknown who are not currently in existence, but will come into existence when they commit the prohibited tort. Now, that was a case, the Ineos case, where everybody agrees the court was dealing with an interim injunction. And so, in rejecting the argument put forward on behalf of defendants who were speaking for persons unknown, rejecting the argument of Miss Harrison, in fact, although Lord Justice Longmore didn't express it in this way, he was doing no more or less than he was entitled to do in an interim injunction case. His decision to reject that argument at the interim stage was in line with the decision of the Court of Appeal in the Canada Goose case. There is no inconsistency.
Well, he didn't know about Canada Goose.
Well, no, of course, it predated.
He doesn't seem to know about any. He doesn't seem to make any anything out of it being an interim injunction, and that's why it's allowed.
Well, you're quite right, my lord. Other than well, he knew it was an interim injunction, obviously.
No, he knew. He said it was.
But he doesn't make that as being that. He doesn't explain it in those terms, whereas Canada Goose does. But he's silent on that, and one cannot infer, in my respectful submission, that he was in some way endorsing the grant of final injunctions against newcomers.
He goes much further than that. He holds there's no conceptual or legal prohibition on suing persons unknown who are not currently in existence.
Yeah,
but will come into existence when, i.e. whenever, they commit the prohibited tort.
Yes, but
I mean, what's that got to do with interim injunction?
He's already indicated in paragraph 29, the second sentence, I'm sorry. In my judgment, it's too absolutist to say a claimant can never sue persons unknown unless they're identifiable at the time the claim form is issued. Well, that concords with the statutory scheme in the Town and Country Planning Act and Canada Goose.
Yeah, okay.
So, what I respectfully submit is that there's nothing in Ineos, express or otherwise, to say that the Court of Appeal in that case acknowledged or indeed concluded that final injunctions against newcomers could be granted. So In conclusion on the point, my lord, my lady, there is no inconsistency between Canada Goose and the earlier decisions of this court in the Gamel case or the Ineos case. Canada Goose explains Ineos, and it refers to it in many places in the judgment. Lord Justice David Richards was a member of the panel in both cases. And so when it comes to the question of precedent, it's my respectful submission that Canada Goose is binding on this court. We've got an extract from the Cross, which was handed up by Mr. Giffen, QC. I'm not going to take you through that, but I would respectfully ask you to perhaps cast an eye on pages 148, 149.
Where is it?
It's handed up, my lord, yesterday. I don't know whether or not.
I don't do handing up. Where is it electronically?
It accompanied my note, was it yesterday morning?
Thank you.
And if it assists my friend, I do intend to go through some of that in the course of my reply.
Thank you. Thank you. So, my lords, I mentioned page references, but can I just ask, and I appreciate I'm really getting close to running out of my time, pages 148, 149 and 158.
158.
158, sorry, my lord, yes. In particular, with reference to decisions made without any argument. So, with reference to Mr. Jones's note on binding precedent then, and particularly paragraph 13 of that note, which I think was sent overnight to your lordships, my lady. Scenario 2B gives rise to what Mr. Jones suggests is a difficult question, that being whether or not Canada Goose is binding on this court. We say, with respect, it's not a difficult decision. Once one analyses the Gamel case and the Ineos case and how it's explained in the Canada Goose case, and that there is no misunderstanding of Cameron. Indeed, Cameron chimes with having, Lord Sumption, having undertaken an analysis of the case law and the statutory regime. His judgment chimes with and is reflected by the Canada Goose judgment, albeit in the context to which they applied it, which is injunction cases. My lords and my lady, we deal with, and I'm only going to touch on this by reference if I may, the reasons why we say that Canada Goose is a case that cannot be confined to protester cases in our skeleton argument. If I can just perhaps provide you with the references, it's in the electronic bundles, my lords and my lady. Our skeleton arguments begin at page 162 and supplementary at 190. I'm going to try and find you the relevant paragraph numbers, which I think. Yes. Sorry, forgive me, my lord. I have my fingers on it.
49.
49, thank you. Yes, paragraph 49, page 178, my lord, my lady. We also address the question of fairness in the context of traveller injunctions, and what we respectfully suggest is the fanciful idea that the hypothetical traveller family from Rochdale, perhaps travelling down to Kent for the summer season, work through the fields, stopping over at Dagenham, finding that they're in breach of a borough-wide injunction, and that they will be perhaps arrested or faced with contempt proceedings if they don't move, would then apply to this court to vary the injunction. Now, it may happen in a planning unauthorised encampment case, unauthorised development case. One can see the logic in an individual wanting to apply to vary an injunction in those circumstances, because they're setting up home and hoping to develop a site, and perhaps in the contemplation of being granted planning permission, perhaps putting an application in. One can see that in that context, a traveller family may well, once they realise that they've perhaps bought a piece of land that's subject to a Section 187B injunction, apply to vary that injunction. And indeed, the court in Gamble and in the Brown case, which is quoted in that case, make it clear that in such circumstances an application to vary must be made. But that isn't the case for the traveller family who might park up on a car park covered by the injunction in Dagenham or another borough, only to be told that they have to leave on pain of contempt, applications being brought against them. Now, we've addressed turning to injunctions against the world, or global injunctions, perhaps might be a way of putting it. We addressed the cases where such injunctions have been made in our skeleton argument at paragraphs 20 to 39. And I'm not going to take your lordship to them now, but they are the confidentiality cases that we've heard reference to. In Canada Goose, the Court of Appeal concluded that there was no justification for protester cases being subject to injunctions against the world.
Can I just ask you something about the mischief of all this?
Yes.
You say that's not the case in the case of a car park where the traveller turns up and sees a notice and finds that he has to leave on pain of being in contempt of court. So that, by implication, is a very unjust situation which we should set our faces against. I'm trying to work out why the landowner knows that travellers use this unauthorised encampment and wants to protect itself from having that usage. There has been a consideration by the court of whether that land should be used for this purpose by travellers in the past, and those on the land had an opportunity to come and contest if they wished to. What is the injustice in a traveller knowing that there is such an order, that it affects camping on this land, having to move on at that stage? I mean, it seems to me that's the nub of this case.
Well, yes, and if the injunction was in relation to one site in a borough, it may be a car park that is heavily used.
One site in a borough.
Yeah, if it was one site in a borough, then I don't think we'd be here arguing about it. And certainly from the NGO's point of view.
But that can't be.
Well, it can for this reason, my lord, because as Lord Justice Coulson explained, wide injunctions have a particular effect on gypsies and travellers because it forces them out of boroughs, out of the whole borough, because it covers all the land that they might possibly be able to camp on as they travel around the country.
But that's a completely different point. Your main point is these orders can't be granted. Final orders can't be granted.
That's
persons
Canada Goose,
unknown.
yes.
And what my lord is putting to you is, if it's one site, why not? To which I think you say, well, it's not one site, but that's not an answer to the question with respect. Because if it can be granted to one site, it can be granted in relation to 2 or 3, and then it's a question of degree, whether it's necessary and proportionate, to use a cliche phrase, to grant it for 171 sites.
As I said, I wouldn't be here arguing about it, but the Canada Goose judgment would rule out the grant of an injunction in relation to 1 or 50 sites if it was to...
but the Canada Goose judgment rules it out on a principal basis that this can never be appropriate as a matter of law.
Yes.
And that's what I'm quibbling about with you. I'm asking you why it should be the law that such an injunction can never be granted in a traveller case. Because it seems to me that it could be extremely just in a case where this particular traveller, for example, knew full well that this was going on, but kept his or her nose clean by staying on their authorised place until the dust had settled, and then comes along and stays there until they catch up with him, and then runs away and lets somebody else come on. So, I mean, just assume that situation, or the situation that you yourself said, the car park, somebody just comes along and sees a car park with a sign up, and has to go away because it's a contempt.
With respect, that wasn't quite the way I put the hypothetical. The hypothetical was the one I adopted from Mr. Justice Nicklin's judgment, which was not that the traveller saw the sign and yet nevertheless moved on to it, but rather moved on and then was informed that there had been an injunction granted, and then was met with a fait accompli. Either you move or you are subject to committal for contempt.
Yes, because Lord Clark said so.
Yes, exactly. Well, yes. And so in those circumstances, that is where the potential unfairness arises. Not in circumstances where a traveller necessarily sees an order and
So
nevertheless...
that's all right. So that's okay. If there's a big sign and it's clearly served to the ground, knocked onto the ground so everybody can see it, and that's okay, isn't it?
Well, on an interim, I mean, we're coming back to Canada Goose. Like, we can't get away from the Canada
No, on a
Goose.
permanent basis.
But yeah, on a permanent basis, that would offend Canada Goose.
But why is it unjust?
Well, it's unjust because
Why is
it doesn't
unlawful?
give... Yeah, well, for the very reasons that the Court of Appeal explained in Canada Goose. That's where we come back to.
It can never be done.
Sorry, Bob.
It can never be done.
It can never be done unless you, in the case of a rolling cast, you identify the individuals not necessarily by name, but by means which we see in the practice direction.
But you wouldn't be identifying any individual in a rolling cast of 1,000 people. You couldn't possibly. You could only identify a category of people, which wouldn't be good enough. It has to be an identification of an individual who is anonymous, and that is not good enough.
You can do that, my lord, and we've seen it in the evidence. There are examples of families who clearly are moving around boroughs and are known as families, but they're not individually identified. But all one needs to do is identify a vehicle which they're travelling in, or a caravan, or provide the court with a photograph, and you've got the description requirement complied with.
And as I understand it, since Mr. Justice Nicklin took hold of this problem, there hasn't been any application for such an injunction.
Well, it may be because that coincides with the pandemic and there hasn't been as much traffic. I do not know. It could be because there is, a reticence on the part of local authorities to take any action before this court makes a decision. But we're in the realms of speculation.
Okay, sorry, I'm sorry.
Not at all, my lord. Not at all. It's important that we deal with these points. But what we respectfully submit is that the fundamental principle identified by Lord Sumption requires that those who are defendants to the injunction application are able to participate in the trial of the final injunction application, and so that they can necessarily make their points, should they have any, as to why the injunction shouldn't be granted, whether it be on a wide basis or in relation to one particular site. That's the nub of it, and we identify the unfairness which we say exists in paragraphs 56 to 60 of our skeleton argument.
What's the basis for allowing breach of the fundamental principle in what you call a worldwide injunction?
Well, those cases so far have all related to confidentiality.
Well, maybe, but then the principle can't be quite that fundamental, can it? If it can lawfully be breached.
They are exceptional cases, as the courts have indicated on every occasion that they've been granted. And the nub of the point, my lord, is this, that without the injunction granted on that basis, the underlying of the protection that the court would otherwise be able to give to the individual, perhaps the non-disclosure of their identity, would or could be prejudiced. Publication, it wouldn't matter by whom, of the identity of the individual who would otherwise keep their identity from public gaze, would be sufficient to give rise to the real fear and risk, whether it be to health or safety or even life or death in the case of in the Venables case. Now, one could not say possibly that in a case where perhaps a court granted a contramundum or an injunction against the world aimed at unauthorised encampments on a piece of land, or a wide injunction on many pieces of land, that the hypothetical traveller family travelling down from Rochdale to Kent, parking up on a caravan, in their caravan overnight, would, as it were, that activity would give rise to anything like the sort of prejudice that one sees identified in the confidentiality.
Essentially, you say that confidentiality is entire. Any breach of it, doesn't matter who it's by,
yes,
has broken confidentiality, whereas trespass or nuisance is a matter of degree.
Yes, my lord, yes. And there's a reference in the Spycatcher case to an injunction granted to A in respect to B, not a binding C. I won't take your lordships and my lady to it, but that is a quote from that judgment.
I think, Mr. Wellers, you're going to have to wrap up.
I know exactly, my lord. I thought as much. So, with respect to my learned friends, including the advocates of the court, it's our submission that we have identified a coherent approach in the judgments before your lordships, and indeed the statutory regime under the Town and Country Planning Act. So we're not talking about heresy here at all. And all this is borne out in the Canada Goose judgment, which we respectfully submitted binding on this court. And we can see that there is still scope for final orders against persons unknown, identified in paragraph 92 of the Canada Goose judgment, but subject obviously to the qualification, which is that one has to have at least identification of the individuals by means of a photograph or something of that nature in order to obtain such relief. My lords, my lady, thank you very much.
Thank you, Mr. Willers. Anything else? Yes, thank you. Yes.
My lord, I'm just jumping back in because my lady asked for references to the Porter case, and I have some, and I thought it would be sensible just to give you the references so that my learned friends have them before they speak.
Okay.
That was on the point. I've given you paragraph 98 Lord Scott describing essentially the overlap between the Section 187B power and the Section 37 power, and a few more references that it's not expressed in precisely the same way, but I don't want to take up the court's time with this. I'm just going to give you the key references in the other judgments. Lord Bingham at paragraph 28, Lord Clyde at paragraph 65, and Lords Stane and Hutton don't make the same point, but they both agree with Lord Bingham, and that is at paragraphs 59 and 77. I'm grateful, my lord.
Thank you. Mr. Gibbon.
Lord Snyder, I'm going to address 5 points in my reply. I'll tell you what they are. I'm going to what I call first a plea against categorization. Secondly, what I call the Enfield conundrum. Thirdly, the doctrine of precedent, on which I will spend the longest time. And fourthly and fifthly, very briefly in each case, Ms. Bolton's issue 1 and Article 8. I will probably go to a bit of the lick, but I can say that in response to my Lord the Master of the Rolls request on day 1, I understand a transcript of the argument is on order and is on urgent order or whatever it is that gets it to you soon.
We'll probably get it in a couple of days, which is quite satisfactory. Thank you, Mr. Gibbon.
So, the first point, the plea against categorisation. Lord Snyder, this arises from Mr. Jones' reference in the course of his submissions to a need for the claimants to bring this case within one of the established categories, or his rhetorical question as to what the justification was for the claimant seeking to extend those categories. But my submission is not one about extending categories. Rather, it is that the court should not be attempting to define in advance rigid rules or categories about when newcomer injunctions are legitimate in principle and when they are not. What Section 37 of the Senior Courts Act confers is a universal jurisdiction expressly, which refers expressly to interim and to final injunctions in the same terms. This is not to say, of course, that the approach to that jurisdiction should not be a principled one, but the principles in my submission are those such are identified in Bromley concerning the proportionality of injunctive relief, and in Ineos and Quadrilla about the proper use of precautionary relief, and the guidance in those and other cases about the balancing of rights, including convention rights. And that, in my submission, is exactly where all the sort of points that the learned friend Mr. Willers has been mentioning to you when he was showing you Bromley and Chapman fit in, whether the encampment in question is law-abiding, whether what alternatives are open to the people concerned, what the impact is on others, all fact-sensitive questions. And the problems in my submission begin when, if and when the courts start to draw hard and fast lines and say, never in this kind of case, and whether that is lines between cases involving convention rights and those involving other rights, or between protesters and encampments, or perhaps different kinds of travellers, or in particular, between interim and final injunctions, a distinction which in my submission is elusive anyway. We've had witnessed the effort that's been required to try and sort out what one of the injunctions in Gamble was, the difficulty the judge had with classifying the Wolverhampton injunction. So it's an elusive distinction. It's an unprincipled distinction, and it is productive of very unsatisfactory practical consequences. My second point, which I'll come in a second.
Actually, it was a distinction that we abolished in relation to the basis for appealing cases after many years of finding that the distinction was absolutely impossible to identify.
My Lord, and
between a final order
yes,
and an interlocutory order.
I recall some of that case law, and yes, a lot of waste on collateral.
I mean, it's not a bad analogy because it demonstrates how the thing can never be bottomed out. Never.
Yeah, Lord, I'm not certain with respect to even an analogy. I think it may be quite directly in point. So the final thing to say on my first point is that the approach of addressing the Section 37 jurisdiction by way of putting cases into different boxes has, in my submission in recent years, been consistently and resoundingly rejected in the various House of Lords and Supreme Court decisions cited in Convoy Collateral or Broad Idea, and indeed in Convoy Collateral itself. And I won't turn it up, but may I suggest that the following paragraphs particularly demonstrate that. 24, 26, 29 and 30, 39 to 41, 57, 59 and 120.
None of them in my judgment, I think.
Well, although I think I can say without undue flattery that the minority, given the numbers and identity, may be the most distinguished dissenting minority in United Kingdom legal history.
Well,
the majority one may be the one to come.
You can be ever so distinguished, but ever so wrong.
And but my lord, I mean, if I may be serious for a moment, I mean, I think although your lordship was worried about laying down.
No, I said it was a wonderful exposition.
Yes, your lordship did not dissent from as I understand it, from the thrust of the case law about allowing the jurisdiction.
And there would be a beautiful irony if I were to say if I were to uphold in spades all those paragraphs.
Well, I leave that in your lordship's hands. As to how mischievous your lordship wishes to be when you write this.
I've never been mischievous in my life, Mr. Giffen, I'm pleased to say.
My lord, the second point, the Enfield conundrum. My point here is simply this, that in my submission, neither Mr. Jones nor Mr. Willis has sought to suggest to the court that there is any way of escaping, if they are right, the rock or hard place dilemma that I referred to in opening, namely that either one gets the frankly absurd consequences identified by the judge in Enfield at the paragraph cited at paragraph 155 of the present judgment, which I took you, or, if one wants to avoid those absurd consequences, the interim injunction jurisdiction has to be curtailed as set out in Mr. Justice Nicklin's judgment at paragraphs 186 and 248 sub 8 and 9, to which I also took you. There has been no suggestion that there is any way round that. And it is essentially the absurdity that arises if you say that the court's powers are substantially wider before it has considered the evidence properly than after it has done so. Now, I acknowledge that my learned friend Mr. Jones, in answer, I think, to Lord Justice Lewison on this point, did point out that spy capture already indicates the possibility of wider knock-on effects on third parties at the interim stage. But Lords, apart from being widely regarded as anomalous in itself, we've given the references in the supplementary skeleton, that consequence stems from the existence of an entirely distinct form of contempt of court. It is, in my submission, a wholly different matter from the proposition that the court's powers should narrow at the final order stage in terms of what injunction it can actually grant. And against these far-reaching and, in my submission, highly problematic consequences, no one, in my submission, has put forward any principled reason, coming on to precedent, no principled reason for distinguishing final and interim junctions, provided, obviously and importantly, that acceptable procedural fairness can be attained. But Lord, both, I think my Lord Justice Lewison yesterday and Lord the Master of the Rolls just now, at the end of Mr. Willer's submission, have posed the question, why is there anything more procedurally unfair about granting a newcomer injunction at the final stage, assuming liberty to apply, court's continuing jurisdiction, than there is about doing so at the interim stage? And my Lord the Master of the Rolls asked, why? What is the injustice? And the court will need to decide whether it received a satisfactory answer to that question in my submission. It did not. And if I could just make one final codicil point on that, Lord Justice Lewison asked about the established against the world cases. Now, I would point out that to the extent those are based on convention rights, as they are of one kind or another, Article 6 is part of the convention. So it is hard to imagine that those cases should be regarded as ones in which exceptionally procedural fairness is thrown to the winds. And if they don't throw procedural fairness to the winds, nor would what we are seeking on this appeal. Now, the third point, precedent, and I'm going to ask the court for this to have to hand both my own friend the advocate to the court's note of last night that he took you through this morning, and my note of yesterday morning, and Cross and Harris that came with it.
I don't think I've brought Cross and Harris with me, but I've got the two notes.
What I can certainly hand up another hard copy of that. Does anyone other than my lord need a hard copy?
I've got it.
I hand
I'll have
that
it.
one. My friend Mr. Jones' note, as he said, proceeds from the premise that Cameron does not apply to injunctions. And in my submission, that premise is correct for the reasons which I gave in paragraphs 7 to 9 of my note. We have in fact been over that in argument, and I don't repeat that now. I will also assume in what I say next that Canada Goose cannot be distinguished. So, from those two starting premises, we then have, Mr. Jones, two scenarios depending on whether there is or is not inconsistency between Canada Goose and the ratios of Ineos and Gammon. Mr. Jones' first scenario is that there is such inconsistency. And I respectfully agree with Mr. Jones that would have the consequence that Canada Goose was, per incuriam, or in English, non-binding, unless Canada Goose should be treated as itself a binding authority on the interpretation of those cases, Ineos and Gammel, or the interpretation of Cameron. And that's where we then go into the, is it Starburst, Starburst? Starmark, I'm grateful. Starmark. And what Starmark indicates in summary is that if Court C, your lordships, is dealing with what was decided in Court A, and then Court B's later consideration of Case A, the Court B decision is not a bar to Court C deciding what Court 8 means and whether it's inconsistent. If Court B's consideration is an obviously flawed one, may I put it this way more positively, in order to bind your lordship, you would need to see in Canada Goose a properly considered analysis of the relevant ratio of Cameron or Ineos or Gamel, which was not obviously wrong. But when one looks at Canada Goose, and I'm going to invite the Court to open that, underlay tab 18, page 390.
So your submission is there's no reasoned conclusion in Canada Goose as to the ratio of Cameron, which is obviously right, which is arguably right.
Well, correct, and ditto Ineos, and for good measure Gamel.
And
Yeah.
Yes, yes, exactly. So the relevant section is of Canada.
Sorry, is it a necessary step in that little part of your argument that the explanation of Cameron in Ineos bound the court in Canada Goose? Or was the court in Canada Goose free to come to its own interpretation of Cameron?
My Lord, it is not a necessary step in my argument, I think, but it is a further string to my bow, because if Ineos did, as I submitted did, contain a conclusion reasoned and based upon having heard argument about what Cameron decided, then the court in Canada Goose plainly was not free to depart from it. And if it did, was, if I was really unleashing the Latin, ipso facto ferent curiam.
Don't tempt me.
So the section in Canada Goose is paragraph 89 and following on page 413. My Lord, my dear, I appreciate, of course, that earlier in the judgment, there, really at paragraph 57 onwards, there is extensive reference to Cameron and to Ineos, but there is no analysis of, in my submission, of whether Cameron dictates a distinction between interim and final orders in the case of injunctions, and there is no analysis of whether any such distinction would be consistent with Ineos. When one reads the section, paragraphs 89 to 92 in particular, we've been through it numbers of times, it reads in my submission as if what's said there simply followed from Spycatcher and the other cases cited in it. So what...
Or as if it follows from the summary of Cameron and Ineos.
Yeah, yes, but more, my lady maybe so, but certainly not analysing.
No, exactly.
Yes,
yeah.
absolutely. So it may, I mean, perhaps it can be summed up in this way. The exercise which the appellants are asking the court to perform on this appeal is not an illegitimate exercise in asking the court to second guess a task that has already been performed in Canada Goose. Now, so that's the first scenario, as it were. Because one then needs to ask, is the ability, let me turn it round, is Canada Goose in fact inconsistent with the ratios of Gamel and Ineos? Now, I appreciate the point, I respectfully recognise the point that my learned friend Mr. Willis made about ratio normally resulting from points that have been argued, and I respectfully see why that may make it slightly difficult to say it's part of the ratio of gamble, even though one, at least arguably, has a final injunction there, because there seems to be no argument about that. But in the case of Ineos, in my submission, it's a much stronger proposition to say that it was part of the ratio, that there was not an interim stroke final distinction here. And I say that for two reasons. First of all, I invoke the reference by Lord Justice Longmore that Lord the Master of the Rolls just referred to about no conceptual or legal prohibition. My Lords recall that, which I respectfully adopt what my Lord was putting to my learned friend Mr. Willis. And also, Lords, as I said in opening, the consideration of section 12.3, which was squarely an issue in the Ineos case, was argued and could not have been approached in the way that it was if there was a distinction between interim and final injunctions. So I submit that it is part of the ratio. But, my Lords, even if I was wrong about that, the inconsistency exception in Young and Bristol Aeroplane can still apply. That's the proposition set out in paragraph 5 of my note, and I'm going to go into Cross and Harris to make that good. Well, what we have provided is the whole chapter in Cross and Harris on exceptions to stare decisis. The bit about the Court of Appeal's Civil Division starts at page 143, but I would, where it sets out the Young and Bristol Aeroplane exceptions. I would like to pick it up, please, halfway down page 144. Where it begins, on occasions, a liberal answer has been given to the question, what constitutes conflict? And reference is then made to two divorce cases, or similar. Casey and Casey on the one hand, and Ramsey, Fairfax and Ramsey, Fairfax on the other hand. And then it's said about 6 lines, in Ross Smith and Ross Smith, the Court of Appeal treated the two cases as irreconcilable and chose to follow Ramsey Fairfax. And the point then is in the next sentence. Whatever definition of ratio decidendi is adopted, the rationis decidendi of Casey and Ramsey Fairfax can hardly be said to conflict. But there is a conflict of assumptions underlying the decisions. One assumes that there is, and the other that there is not, a distinction so far as jurisdiction and nullity is concerned between void and voidable marriages. So, inconsistency of assumptions, as opposed to inconsistency of ratios, is sufficient for this exception to apply. And that takes me back to my note on precedent at paragraph 11, little 2, where I say the inconsistency exists, and as it says in the last sentence of that subparagraph, the nature of the conflict we explain at paragraphs 12 to 15 below. Now, paragraph 12, we say the inconsistency between Bromley and what, on this hypothesis, is the ratio of Canada Goose is obvious. And I think everyone has acknowledged that there is an inconsistency, and indeed, the learned friend Mr. Willers, in answer to the Master of the Rolls, found himself unable to dissent from the proposition that this would make a nonsense of all the guidance given in Bromley. So, about as stark a case of inconsistency with respect as one could imagine. But then going on to paragraph 13, we say the inconsistency with Ineos, Quadrilla and Gamble lies in the assumption that was made in those cases that the principles being stated and applied there were relevant to final as well as to interim injunctions. And this assumption, we submit, does not appear only from the complete silence of the judgments as to any distinction between the two scenarios, or the fact that the court in those cases made at most cursory reference even to the interim or final status of a particular injunction which was before it, and though true though those things are. But the decisive point is what we say in paragraph 14. That assumption that the same principles apply is, we submit, necessarily implicit in the fact that in none of these cases did the Court of Appeal find it necessary to pay any attention at all to the question of whether it would be possible, in principle, to grant a final injunction in the same terms at trial, and if not, what implications that had for the appropriateness of the interim relief sought. In other words, the Court of Appeal didn't discuss the Enfield conundrum because its reasoning necessarily assumes that no such conundrum exists, i.e., Canada Goose is wrong. So, there is also, if I had to fall back on it, the Rickard's recognition, from Mr. Jones took it to the case of Rickard's, of an exceptional situation. In other words, this is very much a matter for the judgment of the court, but I submit that the cases here are in a state of confusion. There are very wide-ranging and important implications, as we've seen some examples, if Mr. Justice Nicklin in this aspect of Canada Goose are right. And the reality, in my submission, is that whatever the strict position might be on ratio, this aspect of Canada Goose appears at the end of a judgment as, I hope without being disrespectful, something close to an afterthought. It is not certainly the main basis for deciding the case. There's reference to written submissions after the judgment. And as the court has seen, there is no full distinction of the very important, pertinent case law that this court has had. And in my submission, that should make a very strong case for applying Rickard's, if indeed one has to get that far. And Lords, finally...
So that's right, is it? This arises from post-hearing written submissions?
Well, at least in part it was dealt with that way, because I'm looking at para 92. I pick up what's in the first sentence. I don't think, I'm not suggesting the whole issue only came up post-hearing, but it does look as if that does seem to imply there wasn't complete argument on it orally in the usual way. How significant or otherwise that was is difficult to assess without having been there, but it's clearly it's the after dinner mint more than the main course, if I can put it that way. Then finally on precedent, my note at paragraph 11, little 3, foot of page 3 of the note. Moving on now from saying the inconsistency exception applies to saying that Canada Goose is in fact Havering curiam. We put that forward on two bases. The first, subparagraph A at the top of page 4, is that it was decided in forgetfulness. Forgetfulness and ignorance are the words in. Forgetfulness or ignorance is the phrase in the case law. And even if Bromley was indeed cited to the court in Canada Goose, forgetfulness is an appropriate word to apply where no reference is made to it in the judgment, and although the express acknowledgement in Bromley that such injunctions could, in appropriate circumstances, could be granted on a final basis in the encampment case, can't be described as part of the ratio case, for the reasons that Mr. Anderson explained to you, which I accept. We do submit that if the court had had that in mind, it would surely have been persuaded to adopt a different ratio. And now I just go to the bit in Cross and Harris on that, which is at page 151. Just note in passing at page 149 that, first of all, on page 149 you get the quote, the citation from Morell and Wakeling, which is treated as the locus classicus of the ignorance or forgetfulness formulation. There's also, you can see the facts of Williams and Fawcett, which I think the Master of the Rolls asked the friend Mr. Jones about. But going on to 151, the paragraph that begins in other cases, the Court of Appeal has affirmed the rule to be that a decision is not per curiam unless some pertinent authority was overlooked. And even then, the present court must be satisfied that the omission produced an essential flaw in the reasoning. I think that must mean in the later case, or perhaps the one that's earlier to the court that's wrapped in with the problem. There is a citation from Duke and Reliance Systems. Sir John Donaldson, as Master of the Rolls, said, "I've always understood that this doctrine, the doctrine of per curiam, only applies where another division of this court has reached a decision in the absence of knowledge or a decision binding upon it or a statute, and that in either case it has to be shown had the court had this material, it must have reached a contrary decision." But the text then continues, must may be overstating the matter. In Ashburn-Anstalt, the Court of Appeal departed from its famous decision in Errington about contractual licenses and whether they constituted an equitable interest in land. And it said, and there's the quotation here from Ashburn-Anstalt, it was per curiam in the sense that it was made without reference to authorities, which, if they would not have compelled, would surely have persuaded the court to adopt a different ratio. So my submission on precedent therefore operates at a number of levels, but it is that, for all or any of those reasons, that the court is not bound in the way suggested. My fallback, of course, is to distinguish Canada Goose as a protester case on the basis set out in paragraph 11, little one of the note. I don't repeat that now. The court has indicated that there are unsatisfactory features. I don't, with respect to dissent from that, but if the court is put in this position, it might have to decide whether, if Canada Goose was a case which had made bad law, it was better for the law to be consistently bad, or, as we would submit, for the badness to be confined as narrowly as possible. But if my earlier submissions are accepted, one doesn't encounter that problem. Well, very briefly, the two final points. Dalton's issue 1, we, with respect, agree with Lord Justice Lewison and with Mr. Jones. This is a case of what the court should do, not what the court can do. We agree with Mr. Jones that the court can, of its own motion, act in relation to the varying or discharge of a final injunction. We make no submission as to whether it was or was not appropriate for Mr. Justice Nicklin to call cases. We didn't challenge it at the time. What is important for our purposes is that if the court can exercise that jurisdiction, that should lay to rest any residual concern that there may be inherent unfairness in granting final injunctions against newcomers. And Lord, may I suggest that the narrow, perhaps preferable way the court might act of its own motion goes back to a question that Lord Justice Lewison asked me very early on in the opening. What would happen if one individual came, one newcomer came, that, I may be paraphrasing slightly, that attacked the injunction in a way that implied it shouldn't have been granted against others. And Lord, in that situation, I accept that, I assert that the court would have the power to vary or discharge the injunction generally and might well exercise it. Our supplemental skeleton refers to a case where very much that happened in a commercial case, Mr. Justice Carr. It's called Hubbard, I think. I won't turn it up, but an injunction, an interim, an injunction prohibiting the drawing down of a guarantee was granted both against banks and the buyer of goods. The buyers did not apply to discharge or vary, the banks did, and the learned judge held that he had jurisdiction despite the absence of an application by buyers.
What's the name of that case?
The name of that case is it Hubbard?
That's right, your junior, give it to him.
Harbottle, volume B of the authorities, page 380, and the passages at 391 to 392. And finally, and since I ought to be sitting down, as far as Article 8 is concerned, all I'm going to do is to ask the court to reread the following paragraphs in our skeleton. Main skeleton paragraphs 53 to 62, and supplemental skeleton paragraphs 15 and 19, which set out how this came to be a point on the appeal and why we say the judge got it wrong. The short point is that the judge went too far in saying that Article 8 rights of local residents could never call for the grant of a newcomer injunction, if indeed, contrary to all my other submissions, convention rights is the only route to get there. Unless I can assist the court further, those are my replies.
Thank you very much, Mr. Gibbon. Yes.
Lord, on behalf of Wolverhampton, I gratefully adopt those submissions and, of course, won't attempt to repeat any of them. Can I introduce a factual element into the discussion of fairness? Because the court has been has considered the hypothetical situation of a Mr. and Mrs. Smith turning up at the Dagenham car park to find an injunction in place, and there's been some discussion of the fairness of that situation to Mr. and Mrs. Smith. Well, if they turned up at Wolverhampton, the chances are that they would already know about this injunction. Would your lordships and your ladyship look at page 185, please, in bundle number 1?
Did you say 380?
185. Wolverhampton, I'm told by Miss Caney that she was instructed first to consider the possibility of applying for this injunction approximately 18 months before it ever got to court. There was a long process of the council identifying sites that might be vulnerable and have been subject to intrusion in the passed, and the council had to reach a decision as to whether it was proportionate to apply for the injunction. Having considered that it was, but only because they had resolved to provide a transit site, they applied to the court. But they did not apply to the court for an injunction. They applied to the court for directions as to how they should bring their intended proceedings to the notice of the relevant persons, that is to say, the persons who were likely to be affected by the order. And there was a lengthy hearing in front of a specialist Section 9 judge, at which it was decided, after much discussion, that these steps, which you see at page 186, had to be taken. So, although there is the theoretical fairness issue that the court can never be satisfied, every person potentially affected by the injunction came to know of the intention to apply for it, the court should know that these steps were taken. So, firstly, putting a dedicated page on the website with a link on the landing page to that page, issuing a press release, my lord and lady, Schedule 4 contains a list of some 20 or 30 public newspapers, magazines. At 1.2, it involved posting on Twitter and Facebook. At 1.4, an editorial in the Wolverhampton edition of the Express and Star. At 1.5, a video posted on YouTube. And of course, 1.6, a notice affixed to a prominent part of every site.
And also provision for those to be, each site to be inspected weekly to ensure the documents are still there.
Lady, yes, and until May of this year, when these notices had to be taken down, that was faithfully complied with. But it isn't only that these steps had to be taken to publicise the application. The terms of the publication were also settled by the judge. And one of the schedules contains the rubric that was going to be posted. I won't take you to it now. But that was just the application for the injunction, and of course dealt with service of the claim form. The injunction itself, I think you've already seen, and it at page 209, if anyone wants to go there again, it contains similar provisions for its own advertisement. The court should also be aware that ahead of each of the two reviews of this injunction, similar steps were taken to let the public, the relevant public, know what was being done. And of course, the issue of fairness was very much in the mind of Mrs. Justice Jefford, was very much in the mind of Mr. Justice Stuart Smith, as he then was, very much in the mind of Mr. Justice Martin Spencer. And they all thought that this was, so far as fairness was achievable, fair.
Well, if this is an acceptable way to proceed, one might perhaps expect notice to be given to the 3 NGOs who are intervening in this appeal.
Absolutely, and in future that would obviously have to be done. Although I'm happy to say that they did come to know of this injunction, Wolverhampton's injunction, and participated in the hearing before Mr. Justice Martin Spencer. So the other means of publicising it worked, at least for the second review. So, Mr. Justice Nicklin's decision holds that this can never be fair, that this process can never be fair. In dealing with that yesterday, the day before yesterday, I perhaps emphasised too much the words of Lord Oliver in Spycatcher and of this court in Gamble in pointing out that fairness can be achieved by an opportunity to apply later. But at least now I've pointed out to the court the steps that were taken to make it fair when first applied for. There's been some discussion moving on of the procedure by which these injunctions were called in. And the court should know that Wolverhampton did not object to the calling in of its injunction and willingly participated in the examination of its propriety. But the court should also know exactly how it was done and the orders that Mr. Justice Nicklin made leading up to the hearing in January 2021. So could I trouble the court to take bundle 2 for a moment? We don't have in bundle 2 the order of the 16th of October.
Is that volume 2 of
volume 2 of the document?
Of bundle 1, as it were?
I don't have volumes, but it's called bundle 2.
I'm finding it very hard to find my way around these documents because they're not indexed. It's hardly indexed. So where am I supposed to be looking?
I know it as bundle 2.
Which page?
Page 461. What we don't have in the bundle is the order of the 16th of October, but you've already looked at that. And the first order, which came to Wolverhampton's attention on the 20th of October, having been communicated to them by another authority, not by the court, required that Wolverhampton should answer a lengthy questionnaire by the 20th of November. On the 4th of November, Mr. Justice Nicklin made the order at page 461, which required that by the 20th of November, we had to write a position statement setting out clearly our position on the issues which he later examined. And in giving his reasons for making that order, Wolverhampton were able to detect at a very early stage which way the wind was blowing, particularly his paragraph B on page 463.
Sorry, 463?
Yes.
Paragraph B.
In particular, he said that the reason for the position statement was that he wanted to examine whether the issues of jurisdiction have been properly considered. At 464 is his next order. We asked if, instead of putting in a position statement by the 20th of November, we could have another week. And his lordship granted 5 days, but not a week.
Where's the order of the 16th of October?
That isn't in the bundle. It was handed up separately, well, communicated separately yesterday or the day before.
Was it? Was it in the Enfield case?
No.
Could you ask your junior to send it again
Yes.
to my clerk, if you don't mind?
Yes.
I want to just make sure I've got it.
Yes.
I expect I have, but I just want to make sure.
So we were granted a 5-day extension of time on the 12th of November. But then on the 20th, we complied with the 16th of October order by filing our questionnaire, which we don't need to read, but you can get a measure of its detail by scrolling through or turning the pages at page 467 onwards. And Mr. Justice Nicklin must have read it that day that we filed it, because his clerk sent an email to Wolverhampton at 5 o'clock on Friday the 20th, changing the direction for a position statement by the 25th into a requirement for a skeleton argument by the 27th, dealing with how we say our injunction could survive Canada Goose.
So what is your conclusion to those submissions?
Well, we were faced all along with what appeared to be quite a zealous judge who was expressing deep concern about what other judges had done.
And the other judges were three of his colleagues.
Yes. And he knew that, because he referred to them by name.
So what does this go to? This question, should he have changed their orders? Is that...
Well, that's why I preface these remarks by making clear that we never objected to him reviewing our injunction. The only purpose of this brief tour through these orders was so the court knows about them.
Right. I mean, you've said to us that the judge below was wrong to say it can never be fair to do it this way, and you've shown us all the steps that your clients took. But what does this run up to the judge's hearing contribute to the debate?
Well, it fills in what might otherwise have been gaps in the court's knowledge. That's all. And
when you say it goes to issue 1,
it does, but we never participated on issue 1, as I made clear.
no, it goes to issue 1, but because we see what happened, and it could be said that this is not the way to do it, and Miss Bolton will perhaps say that, but she won't need to make it good with these references because you've done that for her.
Yes. Finally, the court has shown some interest in the wider impact of these injunctions. In the Black Country, 4 local authorities clubbed together to share the expense of getting an injunction against car cruising. And that injunction expired in January, at around the time of the hearing. And Her Honour Judge Emma Kelly, the designated judge in Birmingham, gave a strong indication that she thought that Canada Goose precluded such injunctions and declined to renew it until a full application, on an interim basis, until a full application was made. That application was listed to be heard on the day after this judgment was handed down. In light of the judgment, the 4 Black Country authorities, including Wolverhampton and Walsall, withdrew the application, so that it is now not in breach of an injunction to race your cars in the highways of those 4 boroughs. And that was a consequence of this judgment. Thank you very much.
Thank you, Mr. Anderson. Yes, Mr. Hayes.
Lord, I also adopt the submissions made by my learned friends, the appellants, on the judge's issue 2, and I don't intend to repeat that. Lord, I intend to deal with 4 points concerning section 187B raised by my learned friend, Mr. Jones, the advocate to the court, and then to make 2 other very brief points, if I may. I agree with my learned friend that the principal issue under section 187B is the issue of statutory construction rather than the rules, and that my Lord has my submissions on both of those points. First point is he said there's no suggestion that either Test Valley and Tanner or Bromsgrove and Carthy, being the 2 cases I referred to, referring to the floating population, were referred to in the parliamentary material or by Mr. Carnworth. I've never suggested that they were. the point that I'm making is that this issue of a floating population of gypsies and compliance with planning law was so well known as to be judicially recognised in 1960. That would have been well known by Mr. Carnworth, Queen's Counsel, a preeminent member of the bar in this field, and so too would have been self-evident to the members of Parliament, because here we were dealing with things going on every day in constituencies up and down England and Wales. Second point is that in his report, Mr. Carnworth does refer to cases where injunctive relief was sought under section 222, and these were cases of unlawful development of caravan sites on the Green Belt. For my Lord's reference, it's page 2271 of the report in paragraphs 2.7 and 2.8, in the case of Runnymede and Ball and the Attorney General and Smith. So clearly this was an issue well known to Mr. Carnworth. The third point is that when he spoke of potential improvements and the problems of ascertaining the identity of those concerned, in the report, and my friend took you to it, he said he had in mind the procedures under Order 113. And as my Lord knows, under Order 113, where orders are made, albeit for possession, they are enforceable against whoever happens to be on the land when they are executed. The fourth point is my own friend referred to Lord Scott's speech in Porter and how the principles under section 187B allied with those of section 37. But Lord, the important point to remember is that Porter was not concerned with the newcomer point and whether section 187B on its proper construction extended to that. The issue in Porter was simply whether or not the 187B jurisdiction was original or supervisory. So one can't get a great deal from that. Lord, that's all I wish to say on the 187B. As to the other 2 points, first is this. My learned friend Mr. Jones, in explaining the position as he sees it, post-Canada Goose, spoke of the example of the Shard. And he explained how under the existing law, with Canada Goose as it is, an owner concerned with threatened trespass may be able to obtain an injunction against the world by relying upon Article 2, presumably the risks of life to those engaged in trespasses to their land. The fact that that is the example that my friend was driven to give demonstrates the state in which the law is if Canada Goose bites. Because it means that a landowner who has threatened trespasses to their property and would otherwise satisfy the requirements for precautionary injunctive relief cannot do so simply because of the threats to their proprietary and or commercial interests, but has to scrabble around to fasten onto the risks to life or safety of the would-be trespassers to get through the hoop under the Human Rights Act.
I'm not quite sure I understand how a private landowner can rely on Article 2. It doesn't owe any duties under Article 2.
Well, no, but
Anyway, I'm just thinking now.
yes.
Go back to the days of man traps and spring-loaded guns.
Yeah. So well, we say respectfully, it can't be right. Of course, that's the matter that the court has to grapple with. The final point is, all the cases before the court are traveller cases, except that is because they've been all brought together by Mr. Justice Nicklin. And I understand why my learned friend, Mr. Willers, is anxious to remind the court of all the difficulties faced by the gypsy and traveller community. But respectfully, all of these are issues which this court has already considered in Bromley. If there is power to make these orders, then issues of fairness, proportionality, Article 8, overzealousness by local authorities can properly be catered for already.
And you haven't said a thing about Bromley being wrong?
No.
And nor have any of your colleagues?
Absolutely not.
Right.
No. Bromley bites. And it's right, my lord, to say that it could be said that some of the orders previously obtained were a bit fierce in going for every single piece of open space in the borough. And one could understand...
A bit fierce.
one can understand why Mr. Justice Nicklin may be concerned about that. And indeed, the Court of Appeal in Bromley. But since that time, since Bromley, there's a requirement to be, more cautious.
It was a double whammy, Bromley and Canada Goose, and you're really just attacking. You're happy with a single whammy.
Yeah, yes. Canada Goose, please, my lord, don't start with Canada Goose. I don't like to revisit personal disasters. My lord, but our concern here is not purely the traveller cases. As I said in my submissions 2 days ago, if Canada Goose is right and applies across the board, then the car cruising injunctions that Mr. Anderson spoke about were wrongly granted. Sharif, that I took my lord to, where Lord Justice Bean said it's a classic case where injunction was wrongly decided. There can be no injunctive relief restraining against raves, nor against fly tipping, which even in Bromley at first instance was granted. But we do have concerns about the wider implications, and I know that the court has those well in mind.
I think Mr. Justice Nicklin discharged an injunction against fly tipping, didn't he?
I think he refused to. He said he refused
to grant one.
He refused to grant one. Yes,
Yeah.
that's right. And that's like assist you. Those are my submissions.
Thank you. Miss Bolton.
My lords, my lady, I have a couple of points to pick up on section 187B made by Mr. Jones and Mr. Willers QC. I'm then going to take you to my final order points in response to Mr. Jones. I then need to very briefly take the court to some cases that will be relevant to a point made by Mr. Kimberlin QC yesterday as to the length of an interim injunction. And there's two cases I think that the court probably needs to be aware of in relation to that if it's to consider that point at all. And then finally a Chancery Division case which is actually in the bundle, dealing with persons unknown, being a judgment of Mr. Justice Morgan. So dealing first of all with section 187B point, Mr. Jones took the court to Carnwath report, which is at page 2276 in Authorities Bundle B, particularly the relevant pages, sorry. And you were taken to page 2275, paragraph 10.2 of the report, and paragraph 10.4 of the report. But you weren't taken to paragraph 10.3, and that's quite important because that effectively encapsulates the approach the courts have traditionally taken to applications under section 187B, which I think it would be a mistake to attempt to prescribe too closely the circumstances in which the remedy would be available or the form of order which could be granted. Experience of decisions over the last few years, see Chapter 5, show that the merit of the remedy is in its flexibility and its ability to evolve to meet changing needs. What is required is its recognition in the Act as a normal backup to the other remedies and acceptance that it is for the authority to judge, subject to the ordinary judicial review criteria of reasonableness, when its use is appropriate. That's important because what we mustn't lose sight of is section 187B isn't simply about travellers' injunctions. It's about restraining breach of planning control, which arises in many circumstances, and its flexibility is incredibly important. And it is a very important tool for the local authority, which is obviously tasked with the public function of ensuring planning control within its administrative area. So first of all, it's important when looking at 187B to bear in mind that that was always the approach, was for it to be flexible and to evolve as is needed, not to be confined. Now, Mr. Jones alighted on section 187B2, and you've heard Mr. Bowes' representations in response on that and what is said in Porter, and the view that Mr. Jones, the submission Mr. Jones makes that effectively it's no different to section 37, the section 37 jurisdiction. I adopt Mr. Bowes' points on that. But that's not the point, because that's not what Gamble was decided upon. The Court of Appeal were very clear in paragraph 2 of the judgment in Gamble that they were relying on section 187B3. See that.
Well, we don't need to see it. I think we remember that.
Well, my lord, indeed, you'll see very clearly that that is the basis on which the court take the view they can grant a person's unknown order. It's section 187b3, and they expressly state that in paragraph 2. Now, both Mr. Willers and Mr. Jones make the point that, well, nothing in the practice direction that accompanies section 187b suggests an order for newcomers. Well, that's not particularly surprising, because newcomers as a term in these injunctions is fairly new, and certainly wasn't a word that was traditionally used at the time of the statute. But we do know that the Court of Appeal endorsed granting an order against newcomers, not by looking at the Gamble case, but by looking at the original South Cambridgeshire case, where they considered in detail what the approach should be. And that you find at page 146.
Well, the original case, though, was, as one doesn't say so in the report of, or in the transcript of that judgment, but it's clear from Gemmell itself that what was granted was an interim injunction, and even Canada Goose accepts that an interim injunction can bind a newcomer. What Canada Goose says is that you can't bind a newcomer who becomes a newcomer after the date of the final order.
Milo, there's 2 points, I think, and it links to both Gamble cases, and it's when you look at them both together and remember that Lord Justice Clark was in both of them, that you see that's not a sustainable interpretation of what is going on in the cases. And the first point is, in relation to the first of the South Cambridgeshire cases, you see that paragraph 3 is dealing with the definition being proposed, persons unknown, and there's conversation on that, and the court wants to be clear, and Counsel wants to be clear at the time of the amendments need to be made to that definition following Bloomsbury to remove intention. We then see in paragraph 7 a discussion of the section and what the section permits. We then see County Court Rule Order 49, which is effectively the position under the practice direction now, setting out the basis upon which you can have an order of this nature, any other evidence, and we need to be clear that that's the definition here on the evidence. It's not being identified by, they're not being identified by a photograph or thing belonging to them. They're being identified by what they are doing on the land, so it's on the evidence. And then we see the conversation on service, and that continues again on paragraph 11. So there's a look at how you would serve on that basis as well. And then at paragraph 8, the court is saying, I'm wholly satisfied that the statute gives the court power to make an order of the type sought by the claimant, after having considered exactly what it is that is required under what is now the practice direction for the definition of persons unknown. This is purely, the whole appeal is focused on persons unknown. So first of all, the order is granted on that basis. Then you go to Gamble, which starts at page 165. But the important part of Gamble that makes it clear that you can't read Gamble as in any way just contemplating the position and the definition at the interim stage is not so much as what is said about Mrs. Gamble at paragraph 32 on page 178 coming onto the land and being bound by it at that stage. It's the last sentence. In neither case was it necessary to make her a defendant to the proceedings later. Well, if this was to be approached in the same way as Canada Goose, well, if you didn't make her a defendant to the proceedings later, she would, once the final order was made, she'd be free to do whatever she liked on the land. She wouldn't be in breach of anything. So I don't think when you read those two cases together, which both of which Lord Justice Clark was in, you can possibly approach Gamble that way. Gamble is clearly contemplating an injunction that can be granted at the interim and final stage. And if that's right, that is a definition which binds a newcomer. And that's appropriate because there's nothing in 20.43 that prevents that. Can you describe the defendant by the evidence? Yes, you have evidence of breach of planning control. You have evidence of encampments on land. You can define the defendant by that evidence. The fact it looks forward and binds anybody within that description isn't objectionable under the statute. And that comes back to, again, what was the intention? for a flexible remedy that can evolve to meet the problems. And that's the report was adopted. Those
So in the case of a precautionary injunction, what is the sort of evidence that would identify the defendants in the same way that they were identified in South Bucks and Persons Unknown, South Cambridgeshire rather?
persons entering onto the land identified on the plan at Schedule 1 forming unauthorised encampments on the land.
That's not evidence, though, is it? That's just a description.
No, that's the description based on the evidence you have that that land has been subject to unauthorised encampments and caused harm.
Has been or will be.
Well, you're apprehending it will be again, my lord. That's the point. You can also apprehend where you have a pattern, and this is very much the approach we took to persons unknown aspects of our orders. For instance, where we had schools repeatedly encamped on and closed, we protected schools generally. If that had been a regular target, we sought for schools within that area to be protected. What we didn't do is say, we've got a fear that there might be schools encamped upon, we don't have any evidence of it, and cover that by the injunction. We didn't cover all areas of great green space either. We took areas which were being targeted and there was a realistic link that the neighbouring site would be targeted. Triple SI sites where they had been the target, we protected those. So there is sensible ways of describing defendants by the evidence that which could be applied to a number of sites. And again, that's for scrutiny by the court. That's a matter of the balancing exercise and what is proportionate within the injunction. And Bromley offers a very significant safeguard and reminds the court that they need to look closely at these issues. And I make this point very quickly on that issue. We've heard a lot about borough-wide injunctions. To the best of my knowledge, the only borough-wide orders in these travellers' injunctions were against named defendants who were personally served, who have been identified as significant wrongdoers. There isn't any injunctions, and I'll be corrected if I'm wrong, obtained by any of the local authorities. My only friend is whispering the word de facto to me. I think that was used in Bromley. But again, most of the local authorities, actually, if you were to look at the area, certainly the ones I represented, and I know I wasn't alone in this approach, they may have covered, I think we on some covered up to 300 parcels of land, but that was land registry parcels. I don't think on many of them you would be looking at more than 7 to 10% of an area in its entirety. So it's not, I think we do need to be a bit careful with that terminology. There were some which covered all green spaces owned by a local authority. That arguably wasn't appropriate, but you would then, as a court now, have to consider, is there a transit site? Is there a negotiated stopping policy? What is the level of harm? They're all the factors that would have to be taken into account. And indeed, most of the guidance given in Bromley was guidance urged upon the court by myself and Mr. Wolfe. Indeed, they were set out as what the court should be doing. You'll see in the Redbridge case, the judgment of Mrs. Justice Farby, talking before Bromley about the very detailed equality impact assessment that Redbridge had done. Many local authorities were doing this properly. Some may not have been, but as Mr. Anderson, QC, said before Mr. Justice Nicklin, the court shouldn't throw the baby out with the bathwater simply because some injunctions were rather ambitious. That's not the point. The point is it's important for the court to undertake the right balancing exercise. So, my lords, I say that in any event, an order of this type can be properly granted under Section 187B at the final order stage for the reasons I've given. My lords, touching very briefly, because I think my submission is a little misunderstood on this point. You have Mr. Jones touched upon the Pioneer case that I referred to yesterday. And I want to be very clear on this point. Pioneer was approved at paragraph 30 of Porter as to the limitations of how the court ought to, the views the court ought to have on planning control and decisions which are for the local authority. The point I'm making is I'm not suggesting that the court should take a different approach to planning law than they should to all types of injunctions, but if this court comes to the conclusion that it is bound by Canada Goose, in my submission, Section 187B is clearly, as a planning law, distinguishable from Canada Goose because you're not supposed to import private law principles into planning law, and Canada Goose requires you to do that. And so I'm not urging the court to take that limited approach, but what I am saying is if you come to the conclusion you can do nothing else, you ought to be able to find my submission that Canada Goose does not apply to Section 187B. And my lord, my Lord Justice Lewison, you questioned why it would be different. The simple reason is because the local authority is tasked with public function of maintaining planning control for an entire area of the sector of the community in its administrative area. And to do that properly, it has to have robust powers and rights to seek enforcement action, which perhaps an individual landowner doesn't require, because they have to ensure planning control for their entire area. And that is why we have this codified statute in this
Don't quite
reason.
follow that. As a private landowner, subject to countervailing considerations, I have an absolute right to stop people coming onto my land.
My lord, you do, but you're not
In
tasked.
terms of planning, or the local planning authority, of course they have to make planning judgments about whether a site's worth protecting, whether it's to be a local green space, whether it should be a triple SI or whatever it is, whether something should be a local listed building, all sorts of planning
Yes.
judgments which they make. But I can't see that that should colour the court's view of whether an injunction should be granted.
My lord, no, it's more a point as to why there is this difference and why, in my submission, Lord Scarman is saying in two judgments that you mustn't import these principles into planning law because of the.
Well, that's about the substantive planning law, not about the remedies granted by the court.
Well,
He was saying, don't import notions of abandoning easements and the like into whether a planning permission has been abandoned.
well, my lord, he talks particularly about planning control and the codified statute that has provided the local authorities the duty to and the functions concerning planning control. And of course, they have to ensure planning control for their entire administrative area. And so if there is a difference, then in my submission that difference is because they have
Well,
that
I think
obligation.
we've got this point, but I think we have very little time left, Miss Bolton.
Lord,
You
indeed.
said there were two cases we really had to look at.
My lord, I need to come to my final order point first. I think the court has this point. Mr. Jones fairly summarised my position on whether or not the court could disturb the final orders in these proceedings. And I think he fairly summarised that I would say that his case management PowerPoint would not succeed, should not succeed on the basis that the rules have provided for alternatives through 40.9, 39.3, and an alternative has been provided under the liberty to apply clause. I also rely on the case of Terry. I won't take the court to it now, but of course the point that the court make there that there has to be a case before the court to manage. And of course there isn't until Mr. Justice Nicklin steps in. But I think the court's focus is on the question of should the learned judge have disturbed these orders? And the answer is plainly no, because the basis upon which the learned judge was disturbing these orders was changes in case law. And you'll see in the judgment, if I can take you there very quickly, we were taken to it by the advocate earlier on. It's page 66 of the judgment. 1, His Lordship says at paragraph 136, however, it's legally unsound to attempt to impose concepts of finality against persons unknown. Well, no one's doing that. We're accepting that the court can hear an application from a person unknown. There's no dispute there. So that's not what we're trying to do. But then it goes on to deal with, on page 68, he suggests that if he's basically suggesting that O'Doherty is a inter partes case, an inter authority in this case? Well, first of all of these cases in the traditional sense were on notice. I appreciate that the newcomer may or may not have had a chance to take part, but these were not without notice cases in the traditional sense. But secondly, O'Doherty is the Court of Appeal saying that case law doesn't have retrospective effect. If that's the case, then the judge, on the basis that he intervened in these cases, which was changes in the law, should not have disturbed these orders. And the reason for that is the principle of finality. Because if a court can simply reopen a case on the basis of a change in case law, then we don't even have a principle of finality anymore.
Well, I think we've got that point very strongly.
My Lord, I'm grateful. My Lord's also picking up very quickly, before I go to this other case, on the I think again it's a position the court has understood. Mr. Willers QC gave you a number of different numbers concerning the traveller population. What we're talking about in the nomadic traveller population is around 3,000 people, and I think he fairly accepted that.
Sorry, my lord, I don't accept that. The 22,000 caravans as a whole accommodate a lot of people who have to continue to travel for an economic purpose. So the wholly nomadic are those people who don't have a place to live. But
well, there are a lot of them. I don't think we need to know quite how many, do we, for the points of principle that we're going to have to decide?
My Lord, I'm grateful for that indication. I wasn't sure if it was something I needed to address. If that's the case, I will move on from it. My Lord, the next issue is Mr. Kimbling quite appropriately raised yesterday the issue that if interim relief is only to be given as very short interim relief, that will cause significant problems in a number of cases, and that's a point I fully endorse. Indeed, I have a protester case at the moment concerning animal research organisations which are struggling from the same difficulties as a result of Categorization decision in this case. But if the court is to consider that issue at all, then the court needs to be aware of a case which again involves four of the local authorities I represent in these proceedings, which are the abuse of process hearings which Mr. Justice Nicklin ordered following his hand down of his decision in May. The 5 local authorities I represent who have an interim order are the only ones whose orders were not discharged because they understood that they were aware that they could identify some more names, so before their final orders were heard. So they were effectively granted a stay of execution at that point. Mr. Justice Nicklin has now agreed not to determine the person's unknown element of those cases, pending the outcome of the decision in this court. But he did consider whether the delay in bringing back the proceedings to final order was an abuse of process. And in the circumstances surrounding the countless cases that were before him, was that one, they had either intervened in Bromley or waited on the decision in Bromley before bringing the case back, and two, that following that, they had the difficulties of the coronavirus pandemic, Bromley having been handed down early in January 2020, and local authorities having been assigned to COVID task forces, so their officers weren't even in post to work on the injunction proceedings. To defend these proceedings, of course, they had to waive privilege on a significant amount of material to demonstrate they had been working on the proceedings and bringing it back to trial and what arrangements they had been put in place. And at the hearing, the learned judge...
What's the point you're making, Ms. Bolton?
Well, my lord, it's relevant...
The point was there doesn't have to be a short gap between an interim order and a final order.
Well, my
Now
lord,
you're going into the facts of a particular case.
my lord, what I'm bringing to the court's attention is there was a practice note by the Court of Appeal in 2020 in the case of Asturian Foundation, which we relied upon, and the judge accepted that we therefore weren't abusing the court process by delay, but introduced a new category following a media case concerning gigs and the news group newspaper limited, for which he said if a litigant with an interim injunction did not bring back their case before the court promptly, that would be an abuse of process. He took the view the local authority had therefore abused the court process, declined to discharge their injunction because he accepted they wouldn't have known that this case, which was actually a case concerning relief from sanctions, would have applied in this way, and that this was a new category of abuse. But it is in the bundle because I believe the interveners put the case into the bundle, and your lordship,
Where is it?
It's at page. Sorry, I'm just looking at the front of it now. Lord, apologies. Sorry. It's 2224. And so the court will need to be aware of that case because, of course, it does suggest that it will be an abusive process to hold on to an interim injunction, even for a fairly short period of time. And that's based on gigs and the newspaper group, Newspapers Limited, and the spy catcher principle. So that it's created a new category of abuse. Secondly, my lord, you will also need to be aware of and I think we've sent it into the court, the practice note of the Court of Appeal on delay and interim injunctions, which is the Asturian Foundation and Ali Ibrahim case 2021 Weekly Law Report 1627, which of course is much more generous in its approach, but appears.
Which page in that authority?
My lord?
Which page in Asturian? Or which paragraph?
My lord, it's a practice note for the.
Well, I've been sent the case with the judgment of Lord Justice Arnold. Can't see a practice note.
My lord, bear with me because I put it down. I was simply bringing it to the court's attention for the court to be aware of.
Yeah, but you're not bringing the right thing, apparently, to our attention if we haven't got the practice note. You sent earlier today Asturian and Ryan Giggs. Neither is a practice note.
My lord, the Asturian Foundation is a practice note case. It has it on its, if I may hand it up, it's on the front page.
Okay, it says practice note.
Yes.
But which paragraph are you referring to?
My lord, the whole case is a case concerning the delay process and warehousing of claims, and if it's not a warehousing situation, the court concludes that it's not an abusive process. So,
all right. Okay.
my lord, I simply flag it as a result of what was said.
No, I see that.
So is there going to be an appeal against the decision that you've drawn our attention to at page 2224?
My lord, you know, for these rather uncomfortable reasons, the order was made.
Well, I don't think we necessarily need to know the reasons.
Well, the judgment unfortunately was made 3 months after the order, and at the time of the order, or the order said, was no order on the application. So, I'm afraid, one, we would have needed permission out of time, and two, the local authorities have taken the view, as their cases can continue, that there has been quite a significant expense in these proceedings already.
Right.
But there would have been additional hurdles, it's fair to say.
Okay.
Finally,
We haven't seen these cases. I'm not suggesting I'm
Yeah, I
going to
think
make
you
any
have.
submissions.
Oh, see, I think you've
No.
Asturian.
Yes.
Yeah.
I won't be making.
I think we're on the outer limits of this case at the moment.
my lord, I only purely bring it to your attention because of the comments that were made yesterday about interim injunctions. And
Okay.
my lord, finally, you asked earlier if there were any decisions on injunctions
Yes.
from the Chancery Division. It's not an injunction case, my lord, but it is a persons unknown case from the Chancery Division considering Cameron and coming to the conclusion that the court can depart from Cameron. And it's the Credit Agricole case, my lord, and it's in bundle BC at page 2187.
And it's Morgan J.
My lord, indeed.
Well, we don't need to look at it now, but
You don't need to, my lord. And I make one point. It's a very different set of circumstances. But Morgan J. And one of the reasons for which Morgan J. departs from the approaching Cameron in that case is that nobody would be subject to a default judgment in that case. And whilst the position is very different, of course that's the same under the Part 8 claims here, where we can't seek default judgment. So
Right.
that is worth bearing in mind.
yes.
My lords, my lady, unless I can be of any further assistance.
No, that's very helpful. Thank you very much.
My lords, I have the planning policy for traveller site
Oh,
document.
thank you.
I think it's also being emailed to your lordship, but if I could ask that 3 copies be handed up, and the definition is on the very back page.
Can you make sure you get it emailed?
Yes, I think I understand it has, but I will.
Good. Well, thank you all for your arguments. We will take time to consider our judgments. We obviously considered giving an extemporary judgment this afternoon, but time doesn't permit, so we won't be doing that. When you get the judgments of the court, will you please agree or send us any textual but not substantive corrections, and agree the orders and any consequential directions as to costs, etc. I would say that if there are consequences that need to be dealt with that are detailed and concern the detail of the individual cases, I suggest that you agree that they be sent back to a judge at first instance and not to ask us to deal with them unless they are totally agreed, and even then it may not be appropriate. But I just fire that shot now across your bows just in case you're thinking that we're going to have a substantive hearing on the detail of each of these cases, because I doubt we'll be able to find the time to do that. But may I thank all the counsel, many counsel, and their instructing solicitors for their very helpful arguments and an enjoyable, interesting 3 days. Thank you.
All right.